timelines for divorces and motions and court proceedings. My name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're going to continue our video series designed to educate and inform the public. So please subscribe to our channel. When you talk about timelines, you got to understand something. The court is going to, by virtue of computer generation, establish a timeline. By this date, you have to have motions filed. By this date, you have to have your discovery done, all of that. But timelines, particularly in family law, tend to be softer timelines, meaning that the court will let the parties go beyond timelines if they need the time and if they're progressing forward. The court won't even ask you to come in for a divorce with children to finalize until you're coming up on 6 months. That means something. It means that the legislature in its wisdom determined that these cases will not likely be resolved before 6 months. So when you have, let's say, an early intervention conference as soon as you file your divorce, don't expect that anything at all will be finalized at that conference. It won't. That conference is just designed to acquaint you with the workings of the front of the court. They're not going to make any final issues regarding custody, parenting time support. And if you think that it will, then your expectation is wrong. You've got to realize that the court sets up these things as foundations. The court is building blocks until the verdict is resolved all the way at the end of the case. The court does not make final decisions as the case begins. So frustrating though it may be, you're going to have to be patient on these issues, and you're going to have to realize that the court works on its schedule, not mine and not yours. Same with motions and court proceedings. The court has its ability to make determinations, but it doesn't necessarily mean that it will. And it doesn't necessarily mean that it'll make it in the timeline that you want, because the court does not define the word emergency as you and I define it. You haven't seen your kid in 3 weeks? I regard that as an emergency. Is the kid safe? Is the kid with an appropriate parent, not exposed to drugs or alcohol or violence or anything like that? If the answer to that question is, well, yeah, he's pretty good, then the court no longer regards it as an emergency. So you've got to realize that that's how it goes. So when you file your motion, understand that that's probably more a function of the court scheduling than it is a commentary on whether or not your lawyer did a good job or whether or not the case is regarded as an emergent situation. If you have any questions about your case, reach out. We'll be glad to help you out.